At any rate, the respondents argue Article 138(3)(c) of the Constitution does not envisage a situation where it is the commissioners who personally undertake the task of verifying and tallying the results as entered into the thousands of Forms 34A. Such an undertaking would be humanly impossible, they submit. For good measure, the respondents submit that Section 11A of the IEBC Act provides that the chairperson and members of the Commission are responsible for the formulation of policy and strategy of the Commission and oversight. In their view, the Act does not contemplate a situation where commissioners would be directly involved in the verification and tabulation of presidential election results. The task of verification and tallying, as stated by the respondents, is executed by the staff of the Commission under the direction and supervision of the Commission Secretary, who in turn reports to the chairperson.
versus IEBC and others.
As to whether the chairperson acted unilaterally in
Petition
verifying
number
and tallying the
008
presidential election results
of
at the National
2022,
Tallying Center,
Julian
the petitioners claim
and
that
others
indeed this is
versus
what happened.
IEBC and 3
It is
others.
the petitioner's case that the chairperson
And the last one but not
published
least,
an illegal
petition
gazette
number
notice
009 of 2022, Ruben Kigame Richete versus IEBC and others. In addition to these petitions, we received a total of 24 interlocutory applications and 1 preliminary objection, which were filed in this court. 2 of the presidential election petitions were struck out. That is petition numbers 006 and 009 of 2022 for failure to meet the constitutional threshold as set out under Article 140 of the Constitution. On 29 August 2022, this court also admitted 3 amici curiae briefs by the Law Society of Kenya, the Kenya section of International Commission of Jurists, and John Warubengo and 2 others.
The chairperson of IEBC states that
upon perusing and considering the issues raised in the remaining presidential election petition numbers 001, 002, 003, 004, 005, 007, and 8, the responses and the submissions filed thereto, this court found that all the 7 petitions substantially raised
all the parties'
similar
submissions,
issues and sought
we find
similar
that pursuant
reliefs.
to Article
Consequently, on 30th August 2022, this court ordered that the 7 petitions be consolidated and designated Presidential Election Petition number 005 of 2022 as a read file. From the consolidated petition, the responses filed and submissions filed by all the parties, the court crystallized the following issues for determination. And those issues are there. We have repeated them several times. I will not read them. Having considered and deliberated upon the consolidated petition, the attendant responses, submissions, and also considering the amici curiae briefs, we now make the following determination on issue number 1, which is whether the technology deployed by IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. As noted in the introduction, lack of trust in the electoral system has endured in Kenya for a long time. This led to the introduction of electoral technology following recommendations made by the Independent Review Commission on the general elections held on the 27th December 2007, popularly known as the Kriegler Commission report. That report recommended integration of technology into Kenya's electoral process for registration, identification of voters, and transmission of results. These were enacted in Section 44 of the Elections Act 2011. By this statute, IEBC is enjoined to adopt technology in the electoral process. As a consequence, the IEBC developed a technology known as Kenya Integrated Electoral Management System, KIMS, making Kenya's election process an hybrid as it employed both technology and manual processes. The first, third, and fourth petitioners in the consolidated petition challenged the technology used by IEBC during the 2022 general election. They claimed that the manner in which technology was deployed and utilized fell short of the prescribed constitutional and statutory standards. As regards the audit of the register of voters, they urge that IEBC, pursuant to its elections operations plan, committed itself to conducting an audit of the register of voters by 31st March 2022. To the contrary, they arranged it only publicly availed the audit report on its website on 2nd August 2022, which was only 7 days to the elections. In this report, it was noted that the auditors established serious gaps and risk to the electoral process, including numerous cases of change of voter stations without knowledge or approval of the affected voters. Grant of voter update privileges in IEBC, IDMs, to 14 user accounts unrelated to voter registration. Reducing the accountability of user activities in the register of voters. Presence of 11 active generic accounts on the MBIS application and the 2 MBIS users with the same login identification, risking unauthorized system users, possible interference, change of particulars on the activation of voters in the system. IEBC's failure to set up access, decertification, and user activity review process. And IEBC was also alleged to have failed to respond to requests by auditors for crucial information. On the integrity of the technology deployed, it was the case for the seventh petitioner that in order to comply with Article 86 of the Constitution and Section 44 of the Elections Act, the technology deployed must be simple, accurate, verifiable, secure.
And there are amendments regarding the conduct of the chairperson. The 4 commissioners have not placed before this court any information or documents showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson. Critically, they have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, at the Serena Hotel press briefing, the 4 commissioners acknowledged that Thus far, the entire election had been managed efficiently and credibly. The chairperson, on his part, did not make matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks of midwifing our democracy, an institution that obviously needs far-reaching an election on the basis of a last-minute boardroom rapture, the details of which remain scanty and contradictory between the chairperson of the Commission and some of its members. In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people are participating without hindrance, as they made their political choices pursuant to Article 38 of the Constitution? To do this would be tantamount to subjecting the sovereign will of the Kenyan people to the quorum antics of IEBC. This we cannot do. Clearly, the current dysfunctionality at the Commission impugns the state of its corporate governance, but does not affect the conduct of the 2022 election. In view of the foregoing, we are satisfied that, notwithstanding the divisions apparent between the chairperson and the 4 commissioners, IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 10 of the Constitution. Issue number 7, whether the declared President-elect attained 50 votes cast in accordance with Article 138 of the Constitution.